time now for our Listener's Choice feature. Listener's Choice is an opportunity for us to have you co-curate the content of the show with us. So there are lots of things that we decide with the team what to talk about on the show, but Listener's Choice is an opportunity for you to suggest to us what we should talk about. So what has been suggested to us this morning is pension benefits and when they can be withheld. So we're discussing the circumstances under which an employee's pension benefits can be withheld. Remember, Advocate Andrea Johnson's resignation as the head of IDEC amid the explosive testimony at the Madlanga Commission of Inquiry, that has reignited a familiar question. When someone in public office leaves under a cloud, should their pension go with them? So as pressure mounted for her suspension and for consequences over her conduct, questions were put directly even to the Justice Minister, Mamuluku Kubai. I had her on the show this week, and I asked her if Andrea Johnson's retirement benefits are going to be withheld, because that's a question that a lot of you were asking. And the minister confirmed that since Andrea Johnson is resigning, she's going to keep her pension, because there's no legal basis to withhold benefits that she had already earned since she resigned rather than being dismissed. So that answer sits alongside a string of very different, well-publicized cases in which the state did succeed in freezing a senior official's pension. For instance, think of the former public protector, Busisiwe Mkhwebane. Didn't she have her pension withheld after Parliament made findings against her? And yeah, this is, of course, different because Andrea Johnson, there's no adverse findings yet against Johnson. But she's also clever because she's resigning before the Madlanga Commission issues its final report. And my friend, I'm sure you can tell that that's going to be so scathing on Andrea Johnson. So if that outcome comes when she is still the head of IDEC, I suspect that there may have been a commission of inquiry into her fitness to hold office if she insisted on staying on the job. And she was probably going to end up with a situation where there are multiple adverse findings against her, and maybe then her pension gets affected in a way. I don't know. But she's resigned, and as a result, there's nothing the government can do. So what exactly does the law require before any employee's pension, whether you're in the public or private sector, can actually be withheld? And why not every resignation under scrutiny meets that bar? And I want to know from you if your employer has ever tried to withhold your pension or provident fund payout when you left a job. How did you resolve that, right? What was your experience? Maybe you had a dispute over your retirement benefits after resigning or being dismissed. 011-883-0702 is the number to dial. WhatsApp's 072-702-1702. Advocate Tertius Wessels is the managing director at Strata-g Labour Solutions. He's going to guide us through this conversation. Advocate Wessels, thank you for making time. Good morning.
Good morning, Clement, and good morning to the listeners as well. Always blessed to be on your show.
Why are pension and provident fund benefits so strongly protected under South African law in the first place?
I think what we often forget is that the fund does not belong to anyone else but the member. So it is the member's money at the end of the day. And because there's such a variety of claims that can potentially want to come after an employee's pension, it has to be so strictly regulated, because otherwise everybody is going to want to put their hand in the cookie jar to get something out of it.
Mm-hmm. So there's been a lot of debate and, tensions rising even from those debates around Andrea Johnson resigning versus, the public protector had adverse findings against her, being impeached, and then the state having access to withholding her pension. And I want to find out from what the law actually says, like under what circumstances then can an employer ask a retirement fund to withhold an employee's benefit?
Right. I think the first point of call is that, number one, the employer can never instruct a fund to so-called freeze the pension, right? The fund's board must exercise a discretion under the Act and under their very own rules in as far as when they are going to temporarily withhold someone's benefits. Now, in particular, we look at Section 37D of the Pension Fund Act, and that tells us specifically when the fund may withhold or deduct monies from a member's benefit. So that act says that the deduction or the deductible compensation owed to employer may be for damages caused by the member through theft, dishonesty, or fraud or misconduct, and where there is a written admission of liability by the member or there's a judgment against the member by a court of law. So it's very, very specific. You cannot withhold monies for every type of misconduct that's been committed by an employee. It must be specific and it must relate to theft, dishonesty, fraud, etc. And then you've got the other two qualifying criteria, which is either an acknowledgement, a written acknowledgement by the member themselves or the employee, or an actual court judgment. And those are the circumstances when the monies may be withheld. Now, obviously, the question is that in many cases, you might not have even proven that the person is guilty of a particular offence. And then the question is, if the employee then resigns, can't you touch it? And that's not the case. If you can show that there was an investigation, you've reported a matter to the South African Police Services, it's being investigated, etc., then the fund may withhold that benefit until the final determination is then made.
Okay, so it's for specific misconduct. So you mentioned theft, dishonesty, and others. So something like gross negligence, that can't be enough to justify withholding.
No. So gross negligence in itself is not sufficient for the withholding. There was various case law has dealt with this issue in the past, where it really tries and emphasizes that this mechanism that we have in terms of Section 37D of the Act is not there as a general debt collection method. Now, what you do often will find is that many employers, when they do structure a acknowledgement of debt with an employee, they will then also include a clause in terms of that acknowledgement of debt that should the individual leave the employee prior to having, settled their debt, that the employee then also gives authorization for a deduction to be made from their pension benefit. But that becomes an informed written admission, number one, of liability. And on that basis, they then try and also get the monies recuperated from the pension fund.
Okay, so as an employer, you've got to prove and provide certain documentations before a fund's board of trustees can agree to withhold that payout. So it's not a matter of just informing them of that misconduct, but you've got to support that and motivate for it. And then the board then has to decide whether they're convinced it's the right way to go.
Correct. So the fund weighs, there's a variety of factors that they consider, like you've outlined. And one of it is what's the evidence that you have? Can you show a prima facie case of the alleged wrongdoing, etc.? Where are you? And those, then only will they make a decision on to withhold or not.
Okay. What rights does an employee have, though, to challenge or make representations against the decision to withhold that benefit?
So from an employee perspective, probably the most cost-effective and the easiest way would obviously be to lodge a complaint with the pension fund adjudicator. Now, what then normally would happen is they would acknowledge the complaint. They would then write to the employer and ask the employer to respond to the allegation in writing. And based on those written submissions, the pension fund adjudicator will normally then determine whether the monies can be withheld or cannot be withheld.
Okay, 20 minutes after 11 o'clock. I've got some questions coming from our listeners on 011-883-0702. Send your WhatsApps as well. What has your experience been if you've had a dispute perhaps at work over your retirement benefit after resigning or after being dismissed? Has your employer ever tried to withhold your pension or provident fund payout when you left a job? And as an employer, under what circumstances have you tried to withhold, or have you approached the fund board of trustees with all your documentations to try and get a pension or provident fund withheld? Have you done that before as an employer? Let me know.
Burning questions.
Insightful answers.
Listener's choice.
With Clement Manyathela.
25 after 11 on our Listener's Choice feature this morning. We're talking about the circumstances under which an employee's pension benefits can be withheld. And this is inspired by the debate that we have seen around Andrea Johnson, the head of IDEC, who has decided to resign. She's no longer the head of IDEC. And resigning means that she keeps her pension. I interviewed the Justice Minister, Mamoloko Kubai, this week, and she confirmed that there's nothing we can do. Under labor law, this is what she's earned. And some of you have pointed out to the former public protector, Busisiwe Mkhobane, whom the state successfully withheld her pension. And of course, the cases are different, their positions and how the matters were adjudicated. But I do think it's a legitimate question to ask. So we thought, in fact, one of our listeners thought, let's bring in an expert who can explain the circumstances under which an employee's pension benefits can be withheld. And that's exactly what Advocate Tertius Wessels has done, who's the managing director at Strata-g Labour Solutions. He's the one guiding us through this conversation. So we've spoken about what the law says, the circumstances an employer can ask a retirement fund to withhold an employee's pension fund, the process that you have to follow for that to happen, but also the rights that an employee has to challenge or make representations against a decision to withhold that benefit. I wonder about how long the process takes now, Advocate Wessels. Like, how long can a fund withhold a benefit while a case against that former employee is still being decided? What governs that approach?
Yeah, so what we do find is that often some of these disputes do have a tendency to carry on for quite an extensive period of time. But provided that that dispute is ongoing and a final determination has not been made, one has to appreciate and understand that the fund would be obligated to then still withhold until that final determination is made. Because at the end of the day, this whole provision in the Pension Fund Act that has been provided for would effectively become meaningless for employers if the fund was allowed to or was not forced to withhold the payment until the determination is made. Because as much as you and I might want our case to be finalized, unfortunately, we do not have control over the justice system, and we cannot be prejudiced for the delays in getting matters over the finish line.
So what happens to the withheld money if the employer's case against the employee ultimately fails? Is it a matter of just then, allowing access to those funds?
Correct.
And
so once that determination is made, then it will effectively either say, listen, yes, the employer does have a claim. This is the value of the claim. And they will then process the deduction, and that will be final, and the balance will be released, or they'll say there is no claim, thank you very much, and they'll release the full benefit. Yeah.
And if the employee then there's misconduct that's proven against them, let's say maybe through a parliamentary process, an inquest or a court case, then what happens to that money?
So again, that would be the damages portion, for which the employer can, you'll put in your claim for whatever the value is of the damages caused by the dishonesty, the theft, etc. And that portion will then ultimately be deducted from the employee. Now, but important to understand as well is you've got two elements here. You've got in certain instances where either through a criminal process, you embark on a criminal procedure, and there's a ruling made by the court, or you might have a civil claim in itself also. So it doesn't necessarily have to always be, many people think it has to be a criminal case. It can be a normal civil action that also gets instituted.
Got you. Advocate Tertius Wessels, thank you so much for guiding us through this chat and clarifying what the law says. I think that does help us understand the differences in cases between what Andrea Johnson's context and Busisiwe Mkhwebane's context. And maybe what could have happened here is that you decline her request to resign without serving notice, because if she serves notice, it's going to be 3 months. By then, I imagine the State Capture Commission has sent out its final report, perhaps, or maybe an interim report, another interim report, and then maybe that has got, because there are going to be adverse findings against her, and then you start approaching it from that matter. Maybe that's the chance that existed for her pension to be withheld. But as it stands now, she's resigning, the president has accepted that, and she's going to walk away with the pension.
Hanging out with Clement
On 702.
Let's walk the talk.